the ownership of the 86 companies that have been authorized by Health Canada to produce and sell cannabis, okay? Among the 86 companies, 35 are financed through fiscal paradise. And I can give you figures, statistics that are mind-boggling. Abcan Global, 12 million from Cayman Island. Aurora Cannabis, 32 million from Cayman Island. Kentrust Holding, 2 million. Supreme Cannabis Corporation, 10 million. Cannabis Sweeten, 20 millions. Hydropothecary, 15 millions. Delson Therapeutics, 3 millions. Emblem Cannabis, Cayman Island, 8 million. Gold Leaf, 5 million. Invictus, Cayman Island, 14 million. American Group, 9 million. And it go on, I could go on the list and give you, that's only for Cayman Island. So my preoccupation is that the way that Health Canada is granting the permit, the way that they screen where the money comes from is not sufficient to guarantee Canadian taxpayer that in fact we are not doing through the back door what we are trying to eliminate from the front door. Seems to me that they are come back from the back door through the Cayman Islands, through fiscal paradise. So what I did when I read that report, I consulted the form of Health Canada, you know, the form which regulate the information that Health Canada requests from the companies. And of course, the information that they request is pretty simple to bypass. We all know that organized crime, you know, you don't have Maurice Montboucher, the leader of organized crime in Montreal, incorporating under, you know, Boucher Cannabis Corporation and send you his fingerprint, you know, to get a permit. He will do that through all those lawyer firms and all those, you know, how do you call it, accounting firm that I don't need to name, you know, whose name have been published extensively, who will organize for you a way to bypass the front line of the screening. Send your money back to some of those fiscal paradise in Bahamas, in Cayman Island, in Virgin Island, in Switzerland, you know, in Luxembourg, in Hong Kong, in Singapore. You know, it's mind-boggling to see who is financing the companies that have got the permit. So really, if we want to, you know, address the organized crime, we have to strengthen the criteria and get the identity of that money that comes from, you know, the paradise somewhere to support those companies that tomorrow will sell the cannabis that you're going to buy, you know, from the provincial store. This is to me, yes, I'll finish. Yeah, my question is easy. My question is easy. Are you ready to review the criteria to make sure that we know the identity of who hides, where that money that hides behind those smoke screen of identity, so that Canadians know that in fact we have not made it easier for organized crime to get a permit to sell it to the kids and to everyone we want to prevent them from consuming it.
Ministers, you have 3 minutes to answer, Senator Freya.
Well, I certainly appreciate the Senator's passion on this topic, and the government absolutely shares his ambition. The fact of the matter is, today, the cannabis market in Canada is 100% controlled by organized crime. We've got to do better than that. The experience in some other jurisdictions, granted these things are difficult to measure, as the question would imply, But in some states in the U.S., their experience has been, after some 4 or 5 years of a different regime, that the engagement of organized crime has been reduced by something like 75%. And I think that is the kind of statistic that Deputy Commissioner Brasseur would have had in mind when he answered the question in the Senate the other day. The RCMP will obviously be very active and proactive in tracking down the tentacles of organized crime wherever they exist in Canada, whether it be in the cannabis industry or anywhere else. The present regime provides for background checks, for security checks. The federal, provincial, and territorial finance ministers have also arrived at, following ample discussion that was referred to earlier, have arrived at a common agreement that they want the true and real ownership of cannabis firms identified, and they have arrived at agreements among finance ministers in terms of the tracking of cash to make sure that we are able to do that. Madam Chair, I would just make this final point to conclude. We take the Senator's admonition with a great deal of seriousness. What he has described as an objective to eliminate the tentacles of organized crime is an objective that every member of our government shares.
Vous avez 5 secondes. Alors.
You have 5 seconds.
Man the regulations of Health Canada to make sure that we know the identity of who hide behind the money coming from the fiscal paradise involved in the production and sales of cannabis in Canada. Yes or no?
We are prepared to look at every element of our implementation approach to make sure, including this one, to make sure that it's effective.
Thank you, Minister. Senator Boisvenu.
Senator Boisvenu. Continuing along the same lines as my colleague, Senator Joyal, we heard the same things at the Legal and Constitutional Affairs Committee. Senator Joyal said 40% of funding in Quebec currently comes from illegal money. So I understand that the basic premise of Prime Minister Trudeau was to eliminate organized crime by legalizing marijuana. But what we're seeing is that there is another type of criminal replacing organized crime. And what is even more worrisome is that we're hearing names of former Liberal Party members who are involved in these businesses, people who defended organized crime, and money is coming from illegal places. We learned a few minutes ago, barely, that Mr. Ogden, the former head of the RCMP who was fighting drugs, is now part of an organization that will sell marijuana. Does the plan of the Liberal government was to take control of this industry? But it's happening through money from tax havens or names who are associated with the Liberal Party who are going to become involved in this industry. Can the Justice Minister tell us whether she's concerned for the safety of the public? Doesn't it undermine the public's trust in the legalization process, which is being done in a questionable way? Perhaps your question was directed to Minister Goodale, but if you would allow me just a bit of information. A number of licenses were given to producers and to enter the market, and we must be very clear that a number of these permits are people who were associated, they might have been associated with the Liberal party, but they were issued by the Conservative government, and Madam Ambrose was the minister at the time. It's not a partisan issue at all. There's a strict process for the permit issuing process, and we treat everyone fairly and equally to ensure that they have an equal shot at a permit. So I would ask the same question to Senator Joyal. Professor Marois from the University of Sherbrooke, a tax lawyer and specialist who's very well recognized, said that the only way of having transparency in the legalization of marijuana in Canada is to publish all of the names of shareholders who are either involved in the production or distribution of marijuana. Can one of the Madam Minister, Mr. Minister, are you committed to total transparency by ensuring that the names of those investors in marijuana in Canada are publicly known?
As I said, the ministers of finance have had some discussion on that very point to make sure that that ownership is publicly known, and I would be more than happy to have a further discussion with all of the federal officials, including those who deal with corporate regulatory matters, to make sure that the maximum degree of transparency has been accomplished here. And I really do need to make the point that this issue is not a partisan issue. And there are, as the Honourable Senator would know, some very well-known, distinguished members of the former Government of Canada that used to sit across the way in the other place, including cabinet ministers in that former government who are shareholders and investors. So your aspersion to the contrary is not appropriate.
Vous avez encore 6 minutes.
You still have 5 minutes. Last year, in a report in the news, Radio-Canada indicated that even in the therapeutic marijuana industry, criminal groups like the Hells Angels had already infiltrated part of that industry. Are the ministers here today committed to making sure that the owners and distributors are made public, that we know the names of those people?
On the point of disclosure and transparency, I would want to take advice from the law officers of the Crown in terms of how far we can go. But in terms of the objective about transparency is one that I absolutely share. Whether a particular investor at any particular level in any company in this industry or any other had a prior political affiliation is, quite frankly, pretty well irrelevant. Whether they were members of the Hells Angels, that is very relevant. And that's the kind of information that we need to know and disclose so that Canadians can be assured to the maximum extent possible we're accomplishing the objective of getting rid of the influence of organized crime.
Monsieur, Madame les ministres,
Ministers, Canada, your government is preparing to legalize a drug, and Canadians want to have complete transparency so that the effort to eliminate criminal organizations doesn't mean that they get in through the back door. So will the names of those that produce and sell cannabis be made public?
we committed to maintaining the integrity of the new regulatory system that we're putting in place. And just to be clear, we are lifting the prohibition to allow us to regulate its production and distribution, which currently is 100% controlled by criminals. And it's only by lifting that prohibition and implementing a comprehensive and effective system of strict regulatory control of its production and distribution in every place in this country that we have any hope of displacing organized crime's pernicious control of this. And I, frankly, am not prepared to leave the health and safety of our children in the hands of criminals. And so we are absolutely committed to removing the criminal element from this. All of the participants who make application to Health Canada for a license for its production are subject to rigorous background check. And for all the senior officials and the senior investors in those companies, they are subject to a rigorous background check by the RCMP. And we recognize, we're working with our provincial and territorial partners and with law enforcement, that all of the tools that currently exist for the police to deal with the illegal production, the illegal distribution of cannabis, its illegal importation and exportation, remain in place and remain in the Act. All of the authorities that law enforcement currently has to investigate that illegal production and trafficking activity and money laundering remain in place under this Act. And in addition, through the strict regulatory frameworks that we're putting in place, we've put significantly additional tools and opportunities to intervene effectively and to prevent organized crime's involvement. And we remain committed to maintaining the integrity of that regulatory system that we're putting in place. And we are prepared to work very collaboratively with all our provincial and territorial partners, our international law enforcement partners, and with police services across this country to maintain its integrity and to keep organized crime out of this business. It remains a very significant priority for this government, and we are working hard to achieve that aim.
Mr. Blair, n'oubliez pas, quand...
Mr. Blair, don't forget that the 30% of the market may end up in criminal hands.
Thank you. A question for Minister Goodale and the Minister of Health, or whoever else would choose to answer. It's pretty straightforward. I go back to a media report from last October which stated that the Department of Health in a public notice entitled Blood Drug Concentration Regulations acknowledged it had no guidance for drivers on how to comply with Bill C-46. The staff wrote in the regulatory notice that understanding or explaining legal limits will be, quote, challenging. The staff also said that a single joint consumed within 2 hours of driving might put a person over the legal limit, but as we know, THC levels vary dramatically, as does the individual tolerance level and the size, weight, and physical nature of the smoker. So how long do they wait before they get behind the wheel? The science so far is unable to provide guidance, so what does the government tell users or law enforcement or others on the road? Minister Goodale, I noticed that you commented at the beginning enforcement falls to the local jurisdiction, and that is precisely my concern. We already have extreme pressures on local law enforcements in the province that you and I come from. They say it has neither the training nor the equipment, and the new legislation will no doubt lead to an increase in the number of impaired drivers. So can you tell me whether that notice stands on the part of the Health Department, whether the science remains static, and what your best advice is at this point, Minister Goodale?
The best advice to that direct question, Senator Wallen, is don't drive high, period. If you've consumed cannabis or any other impairing drug, don't get behind the wheel of a vehicle, period. That's the best advice one can give.
For how long? I think that's the issue. A day, an hour, you know.
The problem is the science with respect to drug impairment is not as advanced as the science with respect to alcohol impairment. The process is different. The statistics, though, in terms of the consequences, are very compelling. For drivers who die in a car crash and are tested afterward for alcohol consumption, there's about a 33% record of those who have consumed alcohol. For drugs, it's 40% already under the existing law. So obviously we've got a problem right now, and we have to bring those numbers down to save lives. The way that we are doing it is maintaining the existing law with respect to drug-impaired driving, which has been on the books since 1925. But in addition to that, we're adding 2 new features. Number 1, the ability of police officers to take roadside oral fluid tests, which will assist the officers in establishing reasonable grounds to believe that the driver has drugs in their system, and thereby authorizing the officer to take a blood sample, which would provide the more definitive evidence. The other feature that we're changing in the law is the creation of three new offenses that are not drug-impaired driving per se, but having a certain specified drug content in your blood. And that in itself will be an offense, to have that level in the blood. And the details are laid out in the statute and will be confirmed in regulations. But the point is this. The police will have a simpler roadside test, a more reliable roadside test to apply, and they will also have simpler, more objective offenses to lay charges under, rather than the more complex provisions that exist under the criminal code today. And that will help in the enforcement of safer driving standards on the road.
And as you know, the issue of driving and why the question of advice and timing is so important is because it applies to the workplace and it applies in the military. And there are huge areas where these questions are important, whether you can give some people some idea of timing rather than, levels, and I realize that's hard. And just I would like a comment too on whether the other issue stands, that there's just that regulation stands as it was reported last October? The words in it?
Could you qualify? I'm sorry.
Okay, so this was a Department of Health public notice entitled Blood Drug Concentration Regulations. Had no advice in that regulation on how drivers, and this just isn't for stopping people on the road, it's, as I say, in the workplace as well, that the explanation offered was that explaining legal limits or understanding the legal limits would be, quote, challenging. And the staff also said that a single joint consumed within 2 hours of driving might put a person over the legal limit, but then went on to say, but the levels are very dramatically. So it's trying to narrow down that range of something between 2 hours and 2 days, because it's kind of, or even in some cases 2 weeks, as we're told, that THC could be detected in blood. So these are, to have some frame within to see it is becoming very important.
Well, thank you very much. I have to be very honest, Senator Wallen. I'm not aware of that memo. I'll be very honest. However, I would like to still comment a bit, though, to further on my the comments from my learned colleague, which he gave a good overview of the proposed criminal code amendments or new acts that are going to be put in place there, or laws. I think we also have to focus on the issue of public education and awareness, though, as well. And when we talk about the information and the investments that have been made forward this past winter, we can see that it's really important to demystify the issue of impaired driving when it comes not just to youth, but also to Canadians. It surprises me to think how sometimes people still think that they can drive better when they're intoxicated than they can when they're sober. So that type of information and those conversations are really, really key moving forward. You also mentioned an issue of workplace impairment as well, and I just wanted to comment a bit on that. I think that we also have to recognize that it's a reality that we have to deal with right now. Let it be impairment through medication, through fatigue, through alcohol. I recognize that we have some tests to measure the level of alcohol, but there's an awful lot of other impairments that occur out there that it's very difficult. We don't have those tools to possibly measure it. So it's really important to make sure that this conversation continues, and I'm very pleased that my friend and colleague, Minister Hadju, is having these conversations with her provincial and territorial colleagues specifically to the area of workplace issues, because those are things that we certainly know that we have to work towards effectively dealing with it.
Okay, I don't know whether Minister Blair wanted to. Is there? No? Okay, thank
Senator,
you.
if I-
Oh, go ahead. Yeah,
Just to build on what my colleagues have said, and I think this is a really important discussion that we're having, and I'd like to reiterate what Minister Goodale has said, and it is the basis of the approach that we took in Bill C-46, which is the impaired driving bill. We're taking a precautionary approach. That there is no safe level of THC to be in your bloodstream, in your body, and get behind the wheel of the car. As Minister Goodale said, the scientific evidence, we've taken the best scientific evidence that we have and research. We take great heed to the Drugs and Driving Committee of the Canadian Society for Forensic Science, who has been providing us advice for decades in terms of how to proceed. We have provided in Bill C-46 new tools for law enforcement officers to be able to detect whether or not an individual has gotten behind their wheel of their car, whether impaired by drugs with the oral fluid screening devices. Bill C-46 represents one of the most strictest regimes when passed in the world, and we are incredibly pleased to put this forward, and we will continue to take the advice of the Drug and Driving Committee.
Thank you much, Minister. Senator Batters.
To the Justice Minister. Minister, we have had a criminal court delay crisis in Canada where people charged with first-degree murder are shockingly having their cases dismissed. As our Senate report found last year, a major reason for this court delay crisis is the huge glut of impaired driving cases. In a media article today, we see that your own department authored memos last year which show that your government's decision to legalize marijuana could flood our courts with thousands of new impaired driving cases. Minister, your government made a choice to legalize marijuana rather than just decriminalize it. Your own officials have raised concerns about the massive impact marijuana legalization will have on the number of impaired driving cases. So I'm not looking for you to tell me about other measures to decrease impaired driving rates. That's what you gave me last week at Legal Committee. Specifically, I want to know, why do you, Canada's Justice Minister, believe legalization of marijuana instead of decriminalization will decrease impaired driving rates despite evidence to the contrary?
Well, thank you, Senator, for the question, and it is reflective of a question that you asked me last week when I was honored to appear before the
looking for an answer.
The committee. And the answer in terms of, well, first of all, broadly speaking, in terms of delays in the criminal justice system, I take delays in the criminal justice system incredibly seriously. And we are doing everything we can to ensure that we're moving forward cooperatively and collaboratively with the provinces and territories to address these issues, and we will be bringing forward measures in this regard in the near future. We have benefited certainly from reports that have been provided by the committee that you reference, and we have read those recommendations very closely. And with respect to impaired driving and with respect to Bill C-46, as I said at committee last week, there are significant measures that are contained within Bill C-46 that will, and as you know, Senator, impaired driving represent a significant portion of the cases that are in our criminal courts. One, in terms of the impaired driving bill that we've put forward, whether it be around alcohol impaired driving or drug impaired driving, it is one of the toughest, or could be one of the toughest in the world. And with respect to impaired driving by alcohol, the mandatory alcohol screeners are going to, in our view and based on evidence, act as a significant deterrent for individuals to get behind the wheel of their car when they have consumed alcohol. We've also, within Part 2 of Bill C-46, rewritten the criminal code with respect to impaired driving to put in place measures that will also alleviate delays in terms of what can be brought forward, what can be asked for by way of disclosure, and further to that, looking at the blood alcohol concentration and how that can be proved, and not necessarily having to every time deem an expert drug recognition evaluation officer as being an expert in terms of the drug evaluation and the alcohol evaluation.
Okay, I note your answer yet again does not address your government's choice to legalize marijuana, so I'll assume that you acknowledge that legalization will increase impaired driving rates. But I'll move on. My next question is for the Health Minister. Minister, like many Canadians, I have significant concerns about the serious impact that marijuana legalization will have on the mental health of our youth. Because of these mental health concerns, the Canadian Psychiatric Association has recommended the minimum age of 25. The Canadian Medical Association recommended a minimum age of 21. Yet your government has set the age of 18 as the legal age. Your legislation allows every household in Canada to have 4 huge marijuana plants. With this minimum age and this unprecedented accessibility, it cannot be said that your government is protecting kids. A Statistics Canada study released in December shows a major decline over the past decade in the percentage of young people who use marijuana. This major decline has occurred while marijuana remains illegal. Minister, why isn't your government following the advice of such significant medical organizations to protect the mental health of Canada's youth?
Thank you very much for the question, Senator. Protecting the health and safety of Canadians, and specifically youth, is absolutely a priority for this government. We recognize that Canadian youth are amongst the highest consumer of cannabis within our country. When we look at youth between the ages, again, between 15 and 24, they are amongst the highest users in this country, and also amongst the highest users in developed countries. Moving forward, why we're proposing Bill C-45 is to strictly regulate and to restrict access to cannabis by ensuring that there is a minimum age that's allowed, and also making sure that the products are going to be regulated. We focused on the task force recommendations when it came to setting the minimum age of 18. Why did we do so? We've learned loud and clear that Canadian youth are consuming cannabis at a high rate. If we don't strike a balance with an appropriate age, we are certainly not going to displace the market, and we will see our youth getting access to the product that's going to be illegal and in an unregulated way. Therefore, moving forward, we've indicated that the federal minimum age would be set at 18. With that being said, however, many provinces and other jurisdictions, it's completely up to them to choose if they want to augment that age. I can speak for the province of New Brunswick, my home province. They've chosen to put the minimum age at 19 to be very consistent with the alcohol age. Therefore, different provinces and territories can certainly set a higher age if they so choose. And once again, we certainly want to take, and we are taking, a public health approach. It's really at the heart of our legislation, because we certainly want to ensure that we can restrict access to this product, and also to ensure that the regulated product will be available. And moving forward, that is based on the task force recommendations, and we were very attentive to the work that they've done.
Minister, how do you reconcile your stated desire to strictly regulate when you're allowing every household in Canada to have 4 plants? As well, your entire answer you just gave me said absolutely nothing about mental health. And will you please acknowledge the significant impact that marijuana has on the developing brains of our youth?
Well, for the second part of your question with respect to mental health and health effects regarding cannabis use, in no way are we indicating that legalized cannabis means that there's no risks associated to it. And that is why I'm extremely pleased that our government is investing money in the area of public education and awareness. Why are we legalizing the product is because at this point in time, we recognize that Canadian youth are amongst the highest consumers of cannabis in this country. The current approach is not working. Therefore, moving forward, we certainly want to make sure that we can provide them with the proper access to the proper information to make sure that they can have an informed decision. To the second part of your question with respect to the issue of home cultivation, once again, after careful consideration of the task force recommendation, we feel that Canadians will be able to safely and responsibly grow up to a maximum of 4 plants within their household. Now, with that being said, once again, provinces and other jurisdictions can impose specific requirements if they so choose. Once again, I'll use my home province of New Brunswick. They've ensured that if there's going to be home cultivation, it has to be done in a secure area. The province of Alberta, they've indicated that if there's going to be home cultivation, it has to be indoor as opposed to outdoor. So there are certain restrictions and requirements that can be put in place, but once again, we feel that as Canadians, they can choose to grow a small number of plants in a way that's going to be responsible, and they can do it safely.
Why didn't your government take a federal approach to require those types of strict regulations that you just referenced in certain provinces, but not in all provinces?
I'm sorry, I don't understand your question.
Things like requiring them to be grown in a certain fashion or held securely. Why didn't your federal government take your responsibility to strictly regulate seriously and require those sorts of things with the federal law rather than handing it off to the provinces?
Once again, we've taken the advice from the task force, and we certainly want to ensure that provinces and territories can certainly streamline the provincial legislation that they've put in place. We have heard from provinces and territories differing points of views regarding the issue of home cultivation, and they are, meeting the needs, that are required in their area. And as a result, we've seen differing positions from different provinces and territories. And moving forward, we feel that once again, Canadians will be able to responsibly grow this in their home and do so in a safe way as well.
Thank you very much, Minister. Sénateur Pratt, s'il vous plaît.
Oui, merci.
Thank you. Personally, I agree with the idea of legalizing cannabis, but I have certain concerns and questions about particular aspects of Bill C-45. For example, the limit imposed on possession of cannabis, 30 grams for adults, does not apply except in public places. So I find that intriguing. There's no limit to the amount of, say, dried cannabis in private spaces. There's a limit on the number of plants that can be grown in a residence, but not for dried cannabis ready to use. So a person could have an unlimited amount of cannabis, it seems, in one's own home or in another private space. Some American states have imposed a higher but maximum amount that can be kept in a private household. And the police could, with a search warrant, come into a private home and find a huge amount of cannabis, but there would be no charges that would result from that. I find that a bit strange.
Question in terms of possession rates, and I will underscore both of my comments by stating that we took great heed of the advice that was articulated in the report of the task force. The task force did consider the public possession rates. We put it at 30 grams. Other jurisdictions in the United States were looked at by the task force as well as us. In the United States, it was 28 grams. With the metric conversion, we put it at 30. In terms of private possession limits, as you've stated, we did put 4 plants in place in terms of a private dwelling. That was also something that was considered by the task force. The task force didn't entertain or be specific with respect to the amount of private possession. I will say, however, that other jurisdictions in the United States, as you reference, have put a limit on the number of plants as well that can be held in a private dwelling. Many of them refer to 6 plants that can be in a private dwelling. It's difficult, I will say, to determine the volume that will come from those plants. But again, we deem the 4 plants in a private dwelling as the appropriate way to move forward, and certainly with respect to law enforcement officers, they will proceed during the course of their work, and if there is reasonable cause to enter into a private dwelling, we'll seek the necessary judicial authorization in order to enter into that dwelling.
So just very briefly, to be clear on that, wouldn't there be a way, though I understand that we don't know how much cannabis, usable cannabis, a plant would produce, so it's hard to, but I wonder if there wouldn't be a way to get to a quantity, a possession quantity of what in Massachusetts they call usable cannabis, so that you wouldn't find the police officer that enters a residence wouldn't find himself or herself in a situation where you would have a huge quantity of cannabis, not 300 grams, but maybe 1 kilogram or 5 kilograms of cannabis, where obviously there's something wrong going on, but couldn't act because there's no limit at all on possession of cannabis inside a private residence.
Senator, if I may respond, I've actually gone into many of those houses and encountered that. So let me tell you that volume alone is not prima facie evidence of an intent to traffic. And the police would require additional evidence. And our intent in this legislation is to prevent the illegal trafficking. It's why we've placed what we believe is a prudent limit on personal possession when persons out in public. And it's why the police will still have the opportunity, and the laws are in place, for those who have cannabis for the purpose of trafficking. That remains a serious criminal offense, and all the police authorities to deal with that currently exist are retained in this bill. But quite frankly, the volume alone is not sufficient evidence to establish a prima facie case of an intent to traffic, but in the presence of other evidence, packaging materials, debt lists, that type of thing that the police would encounter, or other evidence that they may gather through their investigations. Volume would be a significant factor when coupled with those other factors, but volume alone in our current laws is not sufficient to warrant a charge of possession for the purpose.
My point would be, isn't that a weakness of the law? Wouldn't it be a good thing for having an offense, a criminal offense, of having a very large volume of cannabis inside the home? Well, that's my point.
A large volume is evidence, sir, but it's not sufficient evidence to result in a charge of possession for the purpose of trafficking. The police are required to produce additional evidence in order to obtain a conviction for that offense.
Thank you very much.
Blair. Senator Munson, you have 8 minutes.
Thank you very much, Chair. Just thinking of adding a little levity to our debate this afternoon. I was wondering what Hunter S. Thompson would be thinking, fear and loathing in the Senate. I'm not so sure that some people might not get that, but that's the way it is. But on a serious note, Pierre-Claude Nolan back in the day with the committee, 16 years ago, called for the legalization of marijuana. And at that time, he talked about scientific evidence overwhelmingly indicates that cannabis is substantially less harmful than alcohol and should be treated not as a criminal issue, but as a social and public health issue. That's 16 years ago, and now we're having this debate right now. So I think the Senate was way ahead of the curve and history in the making. This is long overdue from my personal perspective, but what I'm concerned about are those who, since that time, have had criminal convictions for small amounts of marijuana. And here, over the last 15 years, they walk each and every day with the stain of a criminal record. And yet the government will not issue pardons before this legislation becomes law. Why not?
Senator Munson, As we've said before in the House today, changing this law and changing the entire regime with respect to cannabis is a very large undertaking. It is transformative. The senators and the studies that you have referred to a long time ago in the Senate indicate that some people were thinking in this direction in a very early way, and others have not changed their view up until and including today, and no doubt well into the future. But we have made the public policy decision that the law should change for the very good reasons that we've described here. Undertaking to do so is a very big enterprise. I think the questioning today has indicated how complex and intricate this work is. We have goals and objectives for getting it done in the appropriate way later on this year. But until the law changes, the existing law remains in place. That's a very important principle in Canadian jurisprudence.
But Minister,
you don't rush to a conclusion until you get the job done. When you get the job done, the change has to unfold in an orderly fashion.
But Minister, does it make sense for prosecutors to be laying charges today and getting convictions for simple possession? Does that make sense?
I could have a debate with prosecutors or police forces, but it's the last thing a politician should do. Let the police authorities and those who are in the offices of the directors of public prosecutions and provincial attorneys general make the appropriate decisions about the enforcement of the law. We will bring in at the federal level a new regime that we sincerely believe will be better, but we would not argue during this transition period that members of a government or an opposition or any other political organization should presume to tell prosecutors and police officers how to do their jobs.
And in closing, you said sometime this year, later this year,
We've made it very clear that our goal is this summer.
This summer. That's 8 to 12 weeks after July the 1st. Or
Our goal is this summer in an orderly fashion with all of the pieces sequenced in the right order so that they are effective.
Thank you.
Thank you, Senator. Honorable Sénateur,
Honorable Senators,
conformity with the order of the Senate of December 14th, I'm obliged to stop the proceedings so that the committee can report to the Senate. I know that you will join me in thanking the witnesses.